A very good evening to all of you, and a warm welcome to another episode of Law and Order. And today, Sri Lanka wonders to hang or not to hang. That is the question we have as we ponder on the thought of the implementation of the death penalty and the discourses which surround the death penalty. And today, we are more than happy to welcome our President's Counsel, Saleh Piris, to our discussion at Sri Lanka Rupavahini. Welcome, sir.
Thank you, Sharon.
Sir, now recently there has been a new discourse about the need of a death penalty, and there is already being the process of recruiting the executioner is already in place. And both arguments for and against is in the media, it's in the academic sphere, and we see that there is a popular support of the death penalty if you take the context of Sri Lanka, and also there are many international organizations who are against the death penalty. But before we move on to the discussion regarding whether it's favorable or not, what exactly is the role of the death penalty historically?
Well, the death penalty has been on our statute books ever since the penal code was enacted. And so for certain offences, such as murder, so on, there is the death penalty. And so you have the trial court, which sentences a person to death. And then once the appellate process is over, the record or it is ultimately up to the president to decide on whether a person is executed or not. So Shahara, how it happens is so presently, even now in our statute book, we have the death penalty for murder and also for drugs cases. The death penalty is imposed. So what would happen is the High Court pronounces the sentence of death, then the High Court pronounces that a person is guilty, then the person is asked whether he has anything to say. That is called allocutus, and well, whatever he says is recorded. Then the court pronounces the death sentence, and that is a very very sensitive moment in court. The fans are switched off, the lights are switched off, the court cries out that the court is going to impose a death sentence, and then the judge reads out the sentence of death, and then the person is taken away. From there, of course, that person has options to appeal to the Court of Appeal and then to the Supreme Court. Once the appeals are exhausted, then it is up to the president to decide on whether the sentence is executed or not. Now, before the president does this, the president is required by law to call for certain reports from the Attorney General, the trial judge, and then with those two, the recommendation of the Minister of Justice. And with that, it is put up to the president. And then the president would have to decide on the time and place of execution of the particular prisoner. So Sri Lanka up to 1976 had the death penalty. The last president to implement the death penalty was President William Gopalawa. Thereafter, Sri Lanka has not judicially executed any person since 1976 up to date. So that is the background. So there has been effectively a moratorium on the death penalty. So that is where historically that is how it stood. Well, so once a prisoner is sentenced to death, he is taken to what is called the death row. So in the Valikara prison, you have a particular ward or a row which is called the death row, and at the end of the row you have the gallows. And so at the time and place where a person is, the president decides that he ought to be executed, that person will be executed. Historically, that is how it happened.
And now, with the new discourse about re-implementing the death penalty, now the popular support has been for the implementation of the death penalty. When the Bogambara prisons were opened for the public, there was a book where people could record their insights, and most of the people, a vast majority, had made statements in favor of the death penalty, calling for the re-implementation of it. What would mean the re-implementation of the death penalty for Sri Lanka?
Well, I think for Sri Lanka to re-implement the death penalty, it would obviously mean that we are going back in time to maybe 4 decades ago, where the death sentence was last carried out. So, in fact, I happened to meet a lawyer who had appeared for the accused who was executed, who was last executed in Sri Lanka in 1976. Now, this particular lawyer was a senior president's counsel now, and he had defended this accused when he was a young junior as an assigned counsel. And so he told me, he said, in fact, when he looks back, he feels that if he had the experience he had today, that things may have been different. So I think my view is that imposing the death penalty, by imposing the death penalty or by executing it, Sri Lanka is going back in time.
And also now there have been academic discourses regarding the death penalty for and against. Would you be able to elaborate on this debate?
Yeah, so I think the main argument for is to say that it is a deterrent, and the belief that when the death penalty is imposed, that people who commit capital crimes will stop committing it, or that the capital crimes will be reduced by a person, will be reduced when people are executed. So
due to fear.
Due to fear, so that it would have a deterrent effect. So that is probably the main argument for restoring the death penalty. But there is also the argument that of just deserts, the argument that a person must pay for his crime, and so if you murder, you must be executed. So I am reminded of this the saying which says that when you say an eye for an eye, if you go to implement it, it will ultimately make the whole world blind. So, but that is an argument. That is an argument to say that just deserts or the vengeance. And the most important argument, I would say, is the argument that death penalty would deter crimes. So crimes such as murder or drugs might be deterred when potential offenders see other people being executed. Those who are for the death penalty are of the view that would deter them from committing crime.
I may interrupt you there, sir. Now, there is a recent development where we see an uprise in the crime, especially with regard to drugs, trafficking of drugs, and also when it comes to grave crimes such as murder and grievous bodily harm. So, wouldn't the death penalty be an answer for this rise in the crime rates?
No, but actually I don't think any scientific study has been done whether in fact there has been a rise in crime. So, although this popular version, popular position that the number of murders have increased, I think is not correct. Over the years, the number of, in respect of violent crime, there has been a decrease in violent crime. So, this perception is also as a result of media, where you highlight sensational cases, and so people are under the perception that there is an increase in crime. Relating to drugs, most certainly there would be much more detections now than earlier, and there has been an increase. But the question is whether scientifically any study has been done as to whether death penalty reduces crime. For instance, in the United States, some of the states which have the death penalty have the highest crime rate, whereas certain states which do not have the death penalty have a lower crime rate. There have been studies carried out, and really there is no correlation between low crime and the implementation of the death penalty. I think the best example is the Scandinavian countries, where there is no death penalty which is imposed, but they have a low crime rate. So my thinking is, you want to reduce crime. How you reduce crime is by changing the society itself. I think it is by education, by good methods of investigation, that you reduce crime. But if people think that merely because you have the death penalty, it is going to resolve crime, or crime is going to be suddenly reduced because you execute, I think they are mistaken. There should be a more holistic approach to criminology, to investigating crime, to preventing crime. And I think the emphasis must be on prevention. I think there are changes which have to happen at community level if you want to reduce crime. And if that, for one, I believe that there must be that approach.
And also, please correct me if I'm wrong, you take up the position that the death penalty is not effective. And therefore, would you propose that the law be amended, that we abolish the death penalty altogether, and if so, why?
Yes, so this is my personal view. I believe that the death penalty must be abolished. For one, I feel that I am of the view that the death penalty is cruel. And in a country which respects the right to life, in a country which we are proud and we boast of our religious background, and then I think whatever the religion, I think we proclaim that we should not kill. So I don't think in that background that the death penalty can be carried out. And it is my personal view that the death penalty is cruel and that no one should have the right to take away human life.
And also, is there any legal backing for your proposal? Has there been a moment where people have proposed that the death penalty be abolished altogether?
There have been, in fact, I think Sri Lanka, a few years ago, also Sri Lanka reiterated its position on the moratorium of the death penalty, against the death penalty. And of course, we have not signed the second optional protocol on abolishing the death penalty, the protocol to the ICPR. But nevertheless, the fact that since 1976 executions have not been carried out demonstrate that there is, at least among some sections, there is a view against the death penalty. And that view can be backed. There are several grounds on which you can demonstrate that death penalty should not be carried out.
If you could elaborate on these grounds on why the death penalty should not be carried out.
One of the most important arguments, Shahara, is that there is a risk of wrongful conviction. Of a person being, there is a risk of an innocent man being executed. And now this is a real threat. Now some might say, well, what does it matter? It's one or two people, an innocent man or two might die, but
it's good for the greater good.
For the greater good. But then if it is your brother or sister, or if it is your parent who is at the receiving end, you would not say that. There is the greatest danger in the death penalty, in imposing the death penalty, is the risk of an innocent man being convicted. We have found in the most countries with the most developed legal systems, in the Western countries, there have been cases of people after many years on death row having been sentenced to death being exonerated. There was a case in the United Kingdom. This man was executed about 60 years ago, and about 10 years ago they found out through fresh evidence, through fresh investigation, that it was in fact that he was an innocent man, and he was posthumously pardoned and exonerated. But what good does that do to the family or to the person concerned? We find in so many instances there are cases of innocent people having been wrongly convicted within the judicial system, and they have gone through the appeals process. The appeals process have failed, but after decades later, new evidence has been traced. This has happened in Canada, in the United States, in the United Kingdom, in Australia, in those countries. And in those countries with a relatively developed legal system, and where the rights of the accused are also jealously safeguarded. But even in those countries, there have been instances of wrongful conviction. In some countries today, Shahara, there is a system in place where even post-conviction, after the appeal process is over, a case can be reopened if it is felt that there has been a miscarriage of justice. Now, unfortunately, in our legal system, in Sri Lanka's legal system, we don't have that. We do not have recourse to that. So, in our process, if the High Court trial is over, the Court of Appeal has dismissed the appeal, the Supreme Court has dismissed the appeal, then that is final. There is no legal provision to reopen a case when the appeal process is exhausted, and that leaves room for innocent people to be convicted. And that is a real danger. When you speak to police officers, when you speak to prosecutors, there are instances. I can share with you a story which was told to me by a High Court judge. He told me that he had written, in a particular case, he had written a judgment convicting a person. And he said, as he thought about it, before he pronounced it, the next day, as he thought about it, he felt he should not convict the person. And he said he got up in the morning, he rewrote the judgment acquitting the person. He pronounced the acquittal. And he said after the acquittal, the prosecutor came to him and told him, sir, it is a good thing you acquitted the man. The police told me he was falsely implicated. But this was after, the prosecutor came and told this to the judge only after the case was over. So how many, there are invariably in any legal system, there will be innocent people who are wrongly convicted, either due to false evidence, maybe accidental or for, mistakes in identity, police discrepancies in police investigations, false implications by the investigators. Those are all possible. So then, if a person is falsely implicated, we know very often in criminal cases, we know that sometimes when, especially this happens in the villages, when one person commits the crime, there is a tendency to implicate the entire family. So it is the brother or two brothers who went and commit the crime, the witnesses implicate 5 brothers and say we saw all 5 people at the scene of crime. Now, there are safeguards within the legal system, but those safeguards are not foolproof. And there could be innocent people who are convicted, who are sent to prison wrongly. And again, Sharon, we know that in our criminal system, you are also at a net law, we know that in our criminal system much depends on the strength of the defense. So there are people who are well defended, there are people who are weakly defended in the court. I have come across, in appeal, I have come across cases which have been poorly defended. There was one case where in the case of a particular woman, her husband had molested her daughter and she struck the husband with a catty and killed the husband. A clear case of private defense or exceeding the right of private defense. But the lawyer did not take that defense up. He went in for what we call a total denial, and ultimately she was convicted of murder. So what I want to say is that here in our country, not only in our country, in many countries, sometimes people are convicted and capital punishment imposed because of the weaknesses of the defense, because they don't have the wherewithal to retain defense counsel who can defend them properly. We know that in our system, sometimes if a person does not have money to pay the fees of the lawyers, they are assigned counsel. Some of the assigned counsels are very good. Some assigned counsels have just been admitted to the bar 6 months ago or a month ago, and they are called upon to appear for accused and defend them maybe in capital crimes. Then what happens? So ultimately, the system also much depends also on your ability, on your financial ability to defend yourself. So the risk of the death penalty, it is far more likely that the poorer sections of the community will be executed than people who have the wherewithal to defend themselves. So when you take all these things into account, there is a high risk of an innocent person being executed, and we know it is irreversible. If it's you sentence a man to life imprisonment, 20 years later he can be exonerated. In Canada, there was a case, a man was sentenced to, he was sentenced at the age of 16 to rape and murder. 28 years later, his mother kept on fighting for his cause and proclaiming his innocence. 28 years later, at the age of 44, he was released from prison. They found that the evidence had been false. So do we want do the people of this country want an innocent person executed? There is a Professor Ashworth from Oxford University. He says the rights of the victim will not be achieved by an innocent person being convicted. So, however, it is true, we have to look at the rights of the victims, but the rights of the victims are not, cannot be satisfied if an innocent person is convicted. And all these people who are espousing promoting the cause of the death penalty, how are you going to justify if one innocent person is executed? How are you going to justify that?
And also that brings me to the question, it's more of a social question than a legal question. If there are so many demerits in the death penalty, why does Sri Lankan popular support the death penalty?
Yes, that is because we know, Shahara, sometimes what is popular is not always what is right. There are sometimes the howling mob wants things done, and we think that is popular sentiment. But the demands of the howling mob is not necessarily right. If you look in history, so there are in historical, in religious backgrounds, also in historical background, you have found innocent people being convicted. The United States, there were the mobs who would lynch black men, and the majority wanted those people lynched, but that didn't mean they are right. So the question is, I think this is only a perception. We really do not know whether the public, an informed public might take a different view. But the public have to be informed. The public must be aware of the dangers of the death penalty. I am sure all those out there who cry for the death penalty, if the day one of their children, one of their brothers or sisters are falsely implicated in a case, they will not say that. I had a client, Shahara, he was a police officer. He was remanded. He was an officer in charge of a police station. Then he was implicated of some crime, which he claims he did not commit, and he was remanded. Then he told me, he said, now I understand what it is to wrongly remand a man. So this is in remand. So how much worse it would be if an innocent man is executed.
So in summary of this discussion, before we wind up for today's program, is there a last message you want to give regarding the death penalty, its implementation in Sri Lanka?
Yes, I think that this is if we want to tackle crime, there has to be a holistic approach in tackling crime. You have to strengthen the investigators. You have to strengthen the prosecution. You have to strengthen the laws concerned. In the investigation methods you have to strengthen. You have to provide the wherewithal for them to function, for the police, the investigators, the analysts, so on and so forth. If you do that, and also you approach the community and see how you reduce crime within the community, that is difficult. That is not a quick fix, but that is how countries have set about in tackling crime. But I say that going back to the death penalty, we would brutalize this country once again, and it is cruel. The execution, there is no doubt that it is a cruel and unusual punishment. In some countries they have held that. I don't know whether Sri Lanka we will hold that, but in many countries they have held that it is cruel and unusual punishment. And I think in the 21st century, we should not go back to the barbarity of the death penalty.
So that was an insight into the possible implementation of the death penalty, its merits and demerits. So on behalf of Sri Lanka Rupavahini Corporation, we would like to thank Mr. Saleh Piris, President's Counsel, for sharing his insights about the death penalty and its implementation and about its demerits and merits. And with that, we would like to conclude today's Law and Order program, and we hope to be with you with another discussion to bring you insights into law.